I'm Stacy Butler. I direct Innovation for Justice, and our presentation today is about our work in leveraging regulatory reform to advance access to justice. Joining me today are Tate Richardson and Kaylee Balzer, both of whom are postgrad fellows with I4J and have been deeply engaged in our reg reform work actually for several years, both as law students and as postgrad fellows. Ana Harper Guerrero, who is the Vice President and Chief Strategy Officer at Emerge Center Against Domestic Abuse, which is one of our community partners on one of our projects, and Arizona Supreme Court Vice Chief Justice Ann Timmer. So we're really excited to be here and talk to you about this work. I'm going to start with an overview, and then we'll just pass the torch down this amazing line of women. So I4J is a virtual social justice lab. We design, build, and test disruptive solutions to the justice gap. We're housed at both the University of Arizona College of Law and the University of Utah School of Business. So we're an interdisciplinary lab. We've had 12 different disciplines in the lab, and on any given project, we enroll typically graduate students from 5 or 6 disciplines. Every student who comes through I4J will learn this methodology. This is our design and systems thinking methodology for problem solving. And our students work across 3 impact areas. This is essentially I4J's theory of change. So I'll give you the example of medical debt. In our service impact area, we're looking at regulatory reform opportunities for people other than lawyers to be able to give legal advice on common issues in the low-income population like medical debt. So we'll talk today about our pilot training community health workers and debt relief counselors to be able to give legal advice on medical debt. In the systems area, the work is to make sure that if a person or an advocate goes to the system for something like medical debt, that the system is usable and accessible to them. So you could have heard Sarah talk about our systems work yesterday. You can hear her again today talking about it right after this session. And then in our structure impact area, we know that you can have great services and you can have a system that's well designed, but if the laws on which that system are built are failing or flawed, then no amount of systems or service change is going to matter. So for the issue of medical debt, 47 out of 50 states in this country receive a failing score when it comes to consumer protection on medical debt. So this impact area builds tools like our medical debt policy scorecard, which you can hear Gabriella and Aaron talk about tomorrow morning. So the focus today is from our work in the service impact area. And in this space, we're looking at this system that really is built by and for lawyers. And we're working with a population that is using the system without lawyers. And in part, our traditional legal service model has contributed to this problem by requiring 4 years of college, 3 years of law school, and a bar license to be the person who can provide the legal services. So in our current status quo, only really the most privileged and educated among us are empowered to know and use the law. This lawyers-only service model is contributing to the justice gap in this country, and I know you're all familiar with these statistics, but in a world in which only lawyers can give legal advice, this is where we've landed, and really no amount of pro bono or legal aid is going to get us out of or away from this massive justice gap. I4J works in both Arizona and Utah, and those are the 2 reg reform states. So both of these states have created spaces in which they're willing to think about changing unauthorized practice of law restrictions to allow people with specialized training, but not a JD, to be able to give legal advice. And at I4J, we were really interested as we saw these opportunities emerging to explore how they could be utilized to advance access to justice, particularly for the low-income community members that we work with. And so for the past 4 years, we've been tackling this research question of how we might leverage regulatory reform opportunities to create new legal service models specifically for low-income community members. We have a number of projects in this space right now. Our licensed legal advocates in Arizona, Ana will talk to you about that work today. Those are advocates in a DV social service provider who have been upskilled with the ability to give legal advice. In Utah, our medical debt legal advocates, as I mentioned, community health workers, and debt relief counselors, again, already in the field doing a lot of other things and now adding to their toolkit the ability to give limited scope legal advice on medical debt. Just this week, we got approved to launch Housing Stability Legal Advocates in Arizona. So this will be that same upskilling model applied to the social service sector. And some of the data we'll share with you today comes from a project we're running right now in Utah, looking at how people with specialized legal training and not a JD, I'm trying really hard not to say non-lawyer, are embedded in healthcare and in patient care to provide civil justice problem solving in that capacity. So at I4J, we start every project with empathy, and that means if we're going to explore an issue like how the traditional service model is failing, we need to engage with the community that is experiencing the failure. And so when we started this regulatory reform work, we made an interesting early discovery, which was that regulatory reform wasn't engaging with the community members that were experiencing the failure. And so while in the research community, we've been very excited about regulatory reform as, oh, this is going to be it. Now all of these people, librarians, social workers, organizers, counselors, navigators, they're all going to be able to give legal advice. But as regulatory reform has begun to emerge, that really isn't happening. And so we had this hypothesis that maybe one of the reasons for that is that early reg reform efforts haven't really engaged community around what sorts of new service models they want. And that could be in part because the people who have been launching regulatory reform efforts, which to their credit has been a tremendous amount of work and a huge uphill battle, but they have been largely judges and lawyers. And so when we look at, these are the demographics from the task force in Arizona and Utah that are running the regulatory reform effort. And so pretty early on, we decided in this work, we're gonna need to, there's like several stakeholders here that are gonna need to be involved in the design project process. And one is consumers. So these are the people that we're trying to serve with these new legal service models. Another is community-based organizations who are currently doing a lot of problem solving that attorneys aren't doing around the issues that then become legal issues. And then also working with the decision makers to try to bring consumers and community-based organizations to the table as regulatory reform decisions are being made. We also discovered there's actually a fourth stakeholder in our projects, and that's us. We're the design hub. And so we're going to focus today's presentation on our findings with respect to consumers, community-based organizations, and decision makers, but we found that we've really played a necessary role that we would recommend other jurisdictions consider in bringing all of these people together. So with that, I'll turn it over to Tate to talk about consumer perspectives.
Thank you so much. All right, so consumer insight is at the forefront of our regulatory reform work. And at I4J, we seek to understand how consumers feel about three underlying questions that guide our work. First, will consumers trust someone with legal training but not a JD as their legal advocate? Second, how can consumers best be nudged to engage with advocates who have legal training but not a JD? And last, what types of legal advocate services are most important to people experiencing civil justice issues? As to question one, when asked using client-facing surveying, consumers responded that they trusted someone with legal training but not a JD more than they trust an attorney. In our Housing Stability Legal Advocate Survey, 66.7% of respondents said they were interested in receiving legal advice from an advocate. In contrast, only 16.7% of consumers in the same survey said they were interested in receiving legal advice from a lawyer. Further, in our Utah survey, consumers preferred help from community-based organizations, friends or family, or self-help. As to the second research question of what effectively nudges consumers to engage with advocates who have legal training but not a JD, feedback from consumers in the community indicates that they desire, first, consistency throughout their legal journey. They want the same person to help them with their problem from start to finish. Second, they want their advocate to be credentialed. Consumers want to know that their advocate is qualified to assist them. Credentialing can look different. It can include hours of experience helping other consumers, a number of outside certifications, references from certified experts, and more. Lastly, consumers seek an advocate who is representative. They want to receive services from someone who looks like them, understands their situation, and are trusted members of their community. As to the final underlying question, When asked about the types of legal advocate services that are most important to people experiencing civil justice issues, trauma-informed care was at the forefront of consumers' minds when providing feedback. Further, upstream intervention to people was highlighted by consumers as a way to encourage the resolution of problems prior to court involvement. Last, consumers underscored the importance of journey mapping a given civil legal issue to identify the most important services legal advocates can provide. For example, DV survivors may want assistance with an urgent legal issue like a protective order, while people experiencing debt or housing stability may want upstream help at the first sign of a problem. Now I will turn it over to Kaylee to provide insights into community-based organizations' regulatory reform perspectives.
Thank you, Tate. Can everyone hear me okay? Wonderful. So I4J focuses on 3 main research questions for community-based organizations. First, are community-based organizations aware of regulatory reform opportunities? Second, do community-based organizations want to give legal advice to their clients? And third, what barriers limit community-based organizations' ability to leverage regulatory reform opportunities? First, are community-based organizations aware of regulatory reform opportunities? Through I4J's work in this space, we have found that no, CBOs are generally not aware of regulatory reform opportunities. At the start of each I4J regulatory reform project, the research team engages with many stakeholders, including CBOs, that work in the system. These conversations center around explaining the project, often including education about regulatory reform vehicles and the scope of possibility when leveraging those vehicles. This is often new information for the community-based organization and requires further explanation. Even though CBOs in general are not aware of regulatory reform opportunities, there is an appetite for engagement and collaboration among CBOs if regulatory reform opportunities align with their capacity. Second, do community-based organizations want to give legal advice to their clients? Community-based organizations really value the referral relationships that they've built with their area legal providers. That being said, community-based organizations are frustrated with the siloing of services, and they see the opportunity to provide legal advice in-house as a valuable solution to the current challenges caused by the siloing of legal services. Justice needs, social needs, and health needs impact each other, but are often treated separately. CBOs recognize that the siloing requires that their clients go to many different services to get their needs met, oftentimes when the event that precipitated these needs was a singular incident. This increases the risk of consumer re-traumatization from having to explain their situation to multiple providers over and over again. Further, the siloing of services leads to consumer disengagement with the system because problem solving with multiple providers is not only time-consuming, it's also very confusing. CBOs do want to give legal advice to their clients, as long as they have adequate training. Consumers are already asking community-based organizations legal questions, and staff would like training to properly advise clients. However, it is important to CBOs that this training is manageable and does not take significant time away from their existing duties. CBOs worry about giving the wrong advice and want to ensure that they are credentialed by reputable educational institutions. Additionally, CBOs have the capacity to give legal advice to their clients within their existing client interaction structure. Staff share that their interactions are long enough to provide legal advice, and many clients would benefit from legal advice. They see training and certification as a way of furthering their skill set, and authorization to provide legal advice would help them provide more complete services. Third, what barriers limit community-based organizations' ability to leverage regulatory reform opportunities? The time, education, and financial costs of allied legal professional training and certification are too high. Using Utah's licensed paralegal practitioner program as an example, for LPP certification, you need a law-related degree, such as a degree in paralegal studies, a Master of Legal Studies, or a certified paralegal credential. Additionally, you need 1,500 hours of law-related experience, and you need to pass an exam. This can cost between $600 and $10,000, depending on prior educational experience. In contrast to these requirements, 35% of social service providers have a college degree, and 27% of social service providers earn an income below 200% of the federal poverty guideline. The financial, educational, and experiential requirements for ALP programs are too steep. Other regulatory reform vehicles are also time-intensive. As will be discussed later in this presentation, the Utah Sandbox application can be confusing for CBOs, especially those operating as nonprofits. The Sandbox uses phrases like ownership and company, and the risk category is built on a for-profit model. Figuring out how to adapt the application to their services is very time-intensive for CBOs. Reducing the time and cost barriers may increase community-based organization participation in regulatory reform opportunities. An executive director of a community-based organization told I4J, "If the training were free, both staff and volunteers would take it. Volunteers are always looking to do more help, and this would be a nice thing to offer to staff." CBOs are concerned about legal liability. They ask questions such as who would be responsible for malpractice insurance, and who would be willing to insure people who aren't lawyers to provide legal advice. They want to make sure that any training includes a module about the scope of legal services they would be authorized to provide, because they have concerns about unintentionally overstepping the bounds of certification and exposing themselves up to liability. Last, providing concrete advice is in conflict with ethical codes for some helping professions, many of whom are employed at community-based organizations. One example of this is social workers. Social workers are mandatory reporters in cases of child and vulnerable persons abuse, and have an ethical duty to promote self-determination. Mandatory reporting is not consistent with the legal profession's duty of confidentiality, and telling someone what they should or should not do in certain situations may come into conflict with promoting self-determination. These conflicts are not insurmountable, but careful thought must be given to various duties and responsibilities that may come into conflict. I will now turn it over to Anna from Emerge Center Against Domestic Abuse for reflections on consumer and CBO perspectives.
Thank you. So Emerge Center Against Domestic Abuse is located in Pima County, and we're a fairly large nonprofit, and we serve individuals and families impacted by domestic abuse. And for many, many years, as a part of that system, we've operated a pretty robust lay legal program. And I say lay legal because we, until this project, could not provide any level of legal advice. It was often centered on explaining processes, making sure that folks knew what their rights are, connecting them to attorneys, and those sorts of things. And we have known for many, many years that that's not enough. And that so often people would connect to the best resources our community has to offer and still feel like they were lost, like what they really needed wasn't what they got, or worse, that their life got worse. They felt confused, they had questions, and often just sort of felt rushed through the process and system and didn't know what questions to ask, didn't have enough help to figure out what questions to ask. And these are just the folks that end up with Emerge. Emerge does not serve every survivor in our community, so I also think about folks who don't have advocates, who are navigating the same kinds of experiences alone. And so when we talk about safety and power, access to safety isn't just physical safety, but we're talking about emotional safety and safety within the systems that people have no choice but to use. And safety looks like having access to information, having the power to make an informed decision. And by informed, I mean having the space or time to really think through, if I do this, these are the potential outcomes, and I can plan for those outcomes in a manner that brings me a level of security about my situation. And when we're talking about domestic abuse, the wild card is always the abusive person's behavior, right? That can't be predicted, and it can't be underestimated either. And so the opportunity to really understand what choice I am making within this legal system and what that means for me is safety and its power. And so when I think about the healing process for folks, it's not just having a level of distance from being harmed. It's not just access to therapy, or if that's what someone chooses to utilize for healing, but it's also feeling as if a person can take control of their life. That the balance of power in their life rests with them, even if we still can't predict that other person's behavior. And that, just that piece can propel healing for people. I also, when we talk about systemic barriers to legal support, we have a solid relationship with our legal aid provider, as well as a program called Step Up to Justice, which is another free, low-cost legal service referrals. And those attorneys are overwhelmed by the number of people we serve them. And so when a system is overwhelmed, you have to put limits to that system. And so that looks like we can offer legal advice, but we cannot represent you. We can provide you with a clinic, but there isn't enough space to give you individualized legal advice. And while those clinics are helpful and they're a wealth of information, people are left feeling unsettled, they're left feeling unsafe. They still don't know if the choice they're wanting to make is the right choice for them and their children. Also, and this has been something that has come up. I mean, I've been doing this work since the 90s, so I've met many, many attorneys and witnessed many, many situations unfold for survivors. And when we talk about being trauma-informed, that isn't just, do I understand what domestic abuse is? It's not just that. It's not just that I understand someone who has experienced trauma may struggle emotionally or go into crisis. But it also includes the way I explain things to them, the space that I give them to make a decision, how I prepare them to be in a court hearing. Do I understand what are the coping skills this client, how many lawyers say, what are your coping skills? And let's practice those before we go into this hearing, right? Most people don't have time for that. It's not that they don't care, but there's not enough time for those things. We barely have enough time to prepare the legal things associated with their case. And so having somebody who can help someone through that process, but also understand that trauma is like being on a roller coaster blindfolded sometimes. And you think you kind of know what you're doing and you feel good and you might even be prepared with a plan. And then you get there and it all comes undone. And sometimes when people are in crisis, they might say or do things that they wouldn't do if they weren't in crisis. And so being able to help manage that in acute situations is really critical. I also think when we're talking about orders of protection, which is one of the biggest pieces for domestic abuse survivors, we don't have time often to get to a lawyer. And when we talk about the turnaround time for contested hearings, there is not time often to find a lawyer who will represent that survivor, especially if they have no money. That's just the reality. And so someone who is not, in crisis, has experienced a lot of trauma, then has to go into a courtroom and represent themselves, often against a person who does have an attorney. And that is probably one of the most unfortunate situations that we witness time and time again. And when someone isn't successful in that hearing, it often sets them back, not to mention the safety concerns that arise when an order of protection is removed. So for me, this project has been about certainly addressing those things. And I think initially we had a lot of really big thoughts about, this is going to change everything. Which, and maybe it has in a lot of ways. I think it's changed us. We won't be the same after this project, that is for sure. But also, it's taught us to think differently about partnerships, because where you have really great attorneys in legal aid spaces that are willing to give their time and energy, what if we utilize them differently so that they could help more? And what if we looked at advocates who, many of whom have been in the work for years and years and years and know like the back of their hand how the system works in a layperson's perspective? What if we utilize that expertise differently? Would we get different outcomes? And so I think a part of our story, we have to say, is under the cloud of COVID. And I really do think the story would be told much differently if COVID hadn't happened. But COVID arrived right as we were getting ready to try to launch this project, and it made it really, really difficult. And I'd be remiss if I didn't thank the team at I4J for all of their patience and support through COVID, because there were some really, really hard times trying to figure out not just how to launch this project, but how do we keep services intact for survivors who are now stuck at home, often with their abusive partner. The court systems have shut down. Law enforcement is not responding. We have a communal shelter that we have to transform overnight into a hotel. Our staff are quitting left and right and getting sick left and right. And we launched this project in the middle of that. And so I really do think that there's a piece of this that will look different as we move forward and expand our work. And in our desperation of trying to figure out how not to let go of this project and handle all those things I just mentioned, we missed pieces along the way that I think are really important to name. We know a lot about trauma in our work, and trauma is often the thing that pulls the bottom out of the work with survivors. And by that, I mean, we run a housing program. And when we started that program, people thought, where are you gonna find enough jobs or apartments for people? And what we found is that that's not the issue. The issue is their trauma. Can they get out of bed? Do they feel safe enough emotionally to even show up at that job interview, because they'll get the job? But their trauma will always pull the bottom out of that if we don't look at that and work with that. And so originally when we designed the pilot, we thought survivors are gonna be so excited about this that they're just gonna be signing up left and right, and they're gonna wanna do it, no problem, and they're gonna jump right on board, and that wasn't the case. And so that was a misstep on our part to not have taken more time to do some focus groups and really think through what we knew about trauma and how that would intersect with the pilot. Because when someone is in acute crisis, when they've just come from a violent incident, often they're not going to be in a position to represent themselves, even with support and guidance and advice. It's too much. It's overwhelming. If they're homeless, if they're worried about their children, if their children have been, I mean, there's so many things that happen for survivors that we didn't take into account. So we did that process evaluation all along the way and adjusted as we needed to account for those things. And then the other piece is compassion fatigue and staff burnout. And again, COVID made it exponentially worse. But we had a real hard time getting our staff going in terms of following the evaluation piece and understanding how to implement that. And I really think it was about their burnout and one more thing that we were asking them to do in the middle of this public health crisis. And that was really hard on them while they were also adjusting to all these other pieces. And I think that would be there either way. And then I think we went through the 8-week course, and the attorneys were invaluable, obviously, in that process. And I think going forward, and this is kind of to the point in the slide just before this, thinking about what mentoring looks like and consultation from attorneys, I think is really important, because our staff, even though, and by the way, we picked our top-notch staff to do this pilot. Folks that we knew wouldn't skip a beat, they were solid, never miss anything, they're really on top of their work. And what we found is that they were really nervous when it came time to do the work, because they didn't want to do it wrong. They didn't want to make a mistake. They didn't want to cause someone a legal catastrophe in their life because they missed a procedural issue. And they had it. But I think being able to consult with those attorneys and use that mentoring relationship is really key. And eventually they have worked through it and really found their way in the work. But I think there's something for us to look at in terms of process and how we set up those relationships early on, and then create access for the staff to utilize those relationships. So there is so much more I could say, but unfortunately my slide is up. Justice Timmer, it's your turn.
Oh, sorry, yes, not a problem. And also, I apologize in advance for looking at my paper, but this is a topic that I could talk about for 3 hours, and we're trying to stay on time. So I'll be sharing some decision maker perspectives before I turn it over to Justice Timmer. And it's all about the challenges of leading regulatory reform changes. So again, we identified 3 research questions for regulatory reform decision makers. First, are regulatory reform decision makers considering non-market driven innovation in the design and implementation of regulatory reform? Second, what practical limitations do reg reform decision makers face in designing and implementing reg reform to include non-market driven innovation? And third, what tools and strategies can assist reg reform decision makers in diversifying perspectives in the design and implementation of reg reform to allow for non-market driven innovation? First, are regulatory reform decision makers considering non-market driven innovation in the design and implementation of reg reform? Initial rule changes and application processes assume a for-profit service model. For example, in Utah, the Sandbox application uses terms like ownership and company. Additionally, the risk assessment is based on whether the consumer will purchase an incorrect or unnecessary service. The design of allied legal professional programs assumes that the applicant has a paralegal education and legal experiential background, or has the time, financial means, and work flexibility to complete the coursework, experiential requirements, and certification exam. An often cited reason for the steep education and experience requirements of ALP programs is consumer protection. However, there is no empirical evidence showing that more education and experience mitigates consumer harm. Despite the early design focus on market-driven innovation, courts are generally receptive to changes that make space for non-market-driven innovation. In both Arizona and Utah, the courts have been willing to collaborate with I4J to make space for authorizing these non-market-driven service models. The Arizona Supreme Court has authorized the licensed legal advocate pilot through administrative order and is working with I4J on an expansion cohort. As Stacy mentioned earlier, just yesterday morning, the Arizona Supreme Court authorized the housing stability legal advocate pilot, again through administrative order. Throughout the creation of the MDLA, Medical Debt Legal Advocate pilot, I4J worked with Utah Sandbox leadership to help community-based organizations through the application process. While challenges were identified, Sandbox leadership has continued to work with I4J, seeking feedback on usability and ways to mitigate those challenges. The Office of Legal Services Innovation wants to see more CBOs enter the Sandbox and are working towards lowering the barriers for entry to make that happen. Second, what practical limitations do regulatory reform decision makers face in designing and implementing reg reform to include non-market driven innovation? When reg reform decision makers are judges and lawyers, they bring assumptions to the table about who can safely provide civil legal services. Because of the long tradition of legal service monopolies, decision makers have used attorneys as the baseline for evaluating the potential consumer harm associated with new service models. However, this is not an accurate baseline for the low-income community. because the current status quo for low-income community members is self-representation, not lawyers. In a regulatory reform landscape, low-income community members are not choosing between an attorney and an advocate. They are choosing an advocate or navigating the system alone. Regulatory reform decision makers must consider consumer harm, but they aren't including the consumer perspective. Consumer risk must be balanced against the reality of the unmet civil legal needs in the US. Asking consumers the level of harm they are willing to risk would be beneficial when making decisions about threshold level of risk acceptability. Additionally, reg reform decision makers are navigating uncharted waters with limited court resources for design and implementation. Advancing new regulatory reform efforts must be balanced with the many other demands on the court's time and staff capacity. Creating alternative business structure, allied legal professionals, and sandbox structures also requires staffing and funding to administer these new programs. In addition, those who serve on task forces and committees charged with developing these programs are volunteering their time and balancing it with other work commitments. Last, what tools and strategies can assist reg reform decision makers in diversifying perspectives in the design and implementation of reg reform to allow for non-market driven innovation? Decision makers can include CBOs and consumers. CBO and consumers can and should be able to provide feedback on the feasibility of eligibility, training, certification, ethics, and discipline requirements associated with regulatory reform, so that the reform opportunities align with CBO capacity and the services that consumers not only need, but also what they want. And now I will turn it over to Vice Chief Justice Timmer of the Arizona Supreme Court.
Good afternoon, everyone. Thanks so much for your interest in all of this, and thank you, Stacy, for inviting me, and LSC as well. May I ask before I begin my remarks, raise your hand if you're not from Arizona. Oh, good. So this is all brand new information for the most part, I think. All right, so if I can figure this out. Regulator's view, and I speak to you from the court, not addressing legal decisions, but with our other hat on, which is of the regulator. We have a responsibility to regulate the practice of law in Arizona, just as I assume that probably all of your Supreme Courts do the same things in your respective states. So from that perspective, at least from my perspective, and my colleagues, what we are trying to do is ensure that the public is protected and that the public gets what they need as well, but they have to be protected as a self-regulating profession. So you can see up there, and I'm not going to dwell on all this because Stacey said I have 10 minutes to do this, but you can see that it's tough out there, and that it was always striking to me that U.S. lawyers would have to increase their pro bono efforts 900 hours each to meet the need, to begin to meet the need. That's not going to happen. And I think that lawyers are pretty good about volunteering their time. They do all kinds of things possible, but it's not fair nor is it feasible to think that we're going to solve this problem exclusively on the backs of lawyers. And so we really need to look at other things. So why innovate? Clients, first, access to civil justice. I find, and a lot of this, by the way, I'm getting from Bill Henderson, who's a professor at Indiana, and he kindly lets me use his slides, and he spoke to the task force that we had in Arizona, which I chaired, that made recommendations to our court to make some of the changes that we've made, and Stacy was on that as well as we did have non-lawyers, non-judges on that commission. So we in Arizona, we typically will always have, we've had something like 2,000 non-lawyer volunteers because we want more of the community perspective as much as we can on virtually everything we do. So in this, what's going on? Well, you see here the distinct differences between 2007 and 2012. This is the amount of money that law firms have been making. Good news for law firms, they're making good money and they're doing well. And we want lawyers to do well and to succeed and such, and they're able to give back then to their communities as well. But the purple you see there, that 65.5 on 2007, that is in the amount of billions that were made by what Professor Henderson calls from the people law sector, just regular people that hire attorneys. Well, you look then in 2012, it's at 58.8 billion. That's still quite a startling decrease in the amount of money that firms are earning from regular people. Firms increasingly are representing entities, entities that can afford to pay what law firms have to charge these days, which of course just gets worse the more debt that goes up from tuition that law schools charge, and the debt they have to take out. It all escalates, and you see here what occurs. So there you see just the same kind of graphic of how much firms are getting from which type of client, and it's just starting to shrink as far as regular people. So, why innovate from the perspective of lawyers? And you'll see up here some information about solo and small firm practitioners. This is a survey that was done by something called Clio. Some of you might have heard of or use it. It's a cloud-based billing system. They surveyed their clientele. They had over 60,000 attorneys, that's a lot, respond nationally to tell them, anonymously what's going on, what does their practice look like. And you can see here their hourly rates, hours billed, collected, and income, $422 a day on average, which turns out to be $105,000 a year gross. So that's before they're paying overhead, before they're paying taxes, and that's assuming a 2-week vacation. These lawyers are not thriving. Also, if you look and see how much they're billing and hours they're working, they're spending more time working on the administration of law rather than actually practicing law. Now, why do we care about this, other than that we're just really nice people and we want lawyers to do well, right? Why do we care? Well, from the perspective of clients, most people are being represented by these people, the solos and the small general practitioners. So if they don't thrive, then you have fewer people that are in practice that are able to serve the needs of regular people. And I'm not necessarily even talking exclusively about the low-income folks that we've been talking about here, just regular people. You can see what's happened to lawyers through the years since '97 on up. The blue line is how many people are going to in-house practice. So this is non-government, non-law firm. A lot of those folks that had been in the solo, small, general, they're going to that. It's steady income, it's benefits, it's not being out there scrambling for work and dealing with the administration of a law practice. So we're losing people to these folks as well. So from the court's perspective, we have, you see this is from the National Center for State Courts, and the bottom line, you can read the slide, bottom line is that most civil lawsuits in the United States are really small dollar. So you're looking at, the median and average judgments are what, 2,441, 5,424. If lawyers that are dealing with these matters can't afford to have a large billing rate, so they're passing on these kinds of things. So this tells you that there are people out there still need legal advice, because this is a lot of money for a lot of people. It's a lot of money for me. So, and you could use some legal advice to navigate our, despite what we do, complex, intimidating system. Yet lawyers are, fairly priced out to be able to handle matters such as this. So why technology? Look at this. We all know there's a lot of technology now coming in and filling the vacuum that have been left by the lack of legal advice and legal resources in our country, in our world, really. And we've gone to more of a do-it-yourself legal economy. It's a platform people are comfortable with. I mean, who doesn't use YouTube to figure out how to fix stuff now in their house and that kind of thing? Same thing for getting legal advice. First thing we do is how can we do it on our own and try to navigate the systems that way? And lots of entities, market-based economy, take advantage of that and do very well. Problem is it's not regulated by anyone. So when things go awry, there's nowhere to go to get any type of redress. So here are the takeaways you can see from the clients, the lawyers, and the courts. Each of them have a motivation to innovate and to look and see, do we need to do the things we've always done going into the future? Are there real needs is there a need basis for doing so to protect the community? Remember what I said, we're always out for, are these rules that we have constructed necessary to protect the community, or are they blocking people's ability to ensure that people can get safe, credible, quality legal services? An interesting thing, you think, what defines the legal market? Really, what defines it are our rules of ethics that we have had forever, it seems like. And it really, though, only protects people who can get lawyers who are bound by the rules of ethics. Other than that, they're really, other than some consumer fraud type laws and such on the book, but for representation and that kind of thing, that's our structure. So, what did the Arizona Supreme Court do? After our task force, we had our recommendations and a report that if anybody is really interested, you can read on our website the report still. It ended up being rule petitions and going through our rule process in Arizona to make recommended reforms. And in doing so, by the way, we did go out to the community because we did have feeling that what does the community want? That's who we're serving, the citizens of Arizona, and what are their needs, what are their desires along this line. So we commissioned a poll to ask them about some of the reforms. Overwhelmingly on the major two that we did, we got back, yes, we want this is just the type of thing we need. And then we also did some town halls with this type of thing and got the similar kind of feedback that we need something like this. So what have we done? We have administrative orders that authorize different community-based advocates. You've heard about them, I think all of them now today. We've done just did the housing yesterday. We have pilot projects with Emerge and with our State Bar's Foundation, which the charitable arm, I guess, of the State Bar, also does things like for the domestic violence victims, everywhere except Pima County. Emerge is Pima County, Bar Foundation everywhere except Pima County. We have also, we just have on also going with in a dependency area, at least we're gearing up for that. Places where you're not really seeing the lawyers as much. And we're interested and anxious to get the feedback from these projects to see what we can build up permanently on this. And as was said, Anna said, COVID really slowed all of this down, so there's not a whole lot of information yet. We've always had a legal document preparers program, and that for like the past, always for the past 15 to 20 years we've had that. I think we have 600-700 people who the court licenses to give legal, not advice, but help in legal information. So the idea is that they can help people fill out the forms. People get nervous, how do I do this? And somebody needs to walk them through the forms. That's what these people do. So they're legal document preparers, are not allowed to give legal advice, but it's still considered the practice of law because otherwise we can't regulate them unless it's the practice of law. So it's a piece of it, but not the advice part. We have the new things we have are legal paraprofessionals, and those are people who are entitled to give legal advice. They are licensed by the court. To do so, to get that license, they do have to jump through some hoops. They have to have the educational background or through an experiential program or experiential experience. And also go past what you would think of basically as a lawyer that you have to go through. You have to pass an exam, you have to go past background checks, all that type of thing. If you succeed, you are licensed by the court and you are actually an affiliate member of the State Bar of Arizona as well, subject to their own ethical code, which is essentially the same ethics code that the lawyers have. Also paying the same fees, also going through the same CLE requirements, just on and on and on. Same discipline process the lawyers have as well. Now here's the difference. What's the difference between a legal paraprofessional and a lawyer? Big difference. Legal paraprofessionals are only licensed to distinct subject areas. So there are 4 areas that we currently have. One is, 3 of them you really don't see too many lawyers at all. One is a limited jurisdiction court, so that's your city, in Arizona, it's your city courts and your justice of the peace courts. In civil matters, so that's less than $12,000 involved. So they're entitled to practice there, which means you can go into court, you can argue, you can put in evidence, and you're going to be held accountable at the same standard that the lawyer is is held to. The other area is also limited jurisdiction courts criminal, but only if there's no jail time involved. So there you're talking traffic tickets, anything really that you want to have in that area. The third area that is administrative agencies, as long as the administrative agency allows for it. A lot of them do anyway. I don't know if most of you know, but I mean, IRS doesn't require you to be a lawyer. There's lots of agencies that don't in the federal level, and so same with the state. They allow you to do it. Now we'd rather have them be licensed through our court and regulated and subject to that process, and they can entitled to go before our agency. Now, the area that you do see lawyers, and this is probably the most controversial one, is family law. And where family law, we just don't have enough lawyers practicing in the area. In Maricopa County, where we currently are sitting, and most of the population of Arizona resides, you have, at least during our task force days, the stats said that in 95% of the cases in family law, at least one person was unrepresented, and in more than 75%, both were unrepresented. So there's certainly not enough people there, and that caused problems within the court system as well as the lack of representation. So family law is the big area, and that's sure enough where most people now are being licensed. And they're working for family law attorneys who now have expanded their practices with these licensed paraprofessionals, and they can deploy them, so to speak, to do the cases that really don't merit the lawyer's time with lack of complexity, example, and money that they charge. So it actually has worked out for a lot of the family law lawyers at this point. And the reports we've gotten back so far, at least, we know of 2 or 3 jury trials that have been conducted, and non-jury trials, I guess. And the judges said they did better than a lot of attorneys did. So that, of course, because they're very experienced at this point. All right, then we also have the other thing, which is probably more controversial nationally than the licensed paraprofessionals, and possibly not as much interest to this group, is we have eliminated our ER 5.4, which is the ethical rule that prohibits lawyers and non-lawyers from sharing fees. And so to do so, however, if you want to go into business together and share fees, then we have what's called ABS, your alternative business structure. And you have to be licensed by the Arizona Supreme Court and regulated by the court to do that. So we don't regulate law firms, right? We regulate lawyers and now legal paraprofessionals, document preparers, et cetera. But we will regulate the entity that's an alternative business structure. The idea is that, again, with more innovation and the oversight, and as long as you follow the rules, hopefully people can innovate in how they deliver services to people, and more grouping of services, what I call unbundled services, which are allowed anyway under our ethical rules. Now you can do that as a practice with people. So if you've heard thrown around the terms sandbox from Utah, and you might wonder, well, what's the difference? Here's the easy difference. In Utah, a sandbox is if you have a great idea for how you want to practice law, either from lawyers, or you can be, frankly, all non-lawyers, just like it's pure tech and no lawyers involved. You can go enter the sandbox, and then it's my understanding is it's data heavy, reporting requirements, et cetera, that the court can monitor all of that and then decide if you're safely delivering your legal services to the community, and if you are, you can exit that sandbox and continue to practice law. In Arizona, we were confident enough with how we're structured that we just went ahead and set the rules for these kinds of structures. And so anybody can do it if they're licensed by us, have to follow the set a number of rules. So that's just the difference. It's really 2 sides almost of the same coin. I hope I didn't go too far. Did great. No, great. Thank you very much.
It's always uncomfortable when you give a Supreme Court justice a time stamp. That's always a little uncomfortable. So we're about to close out, and and switch to Q&A, I just wanted to follow up on what I mentioned at the beginning, which is this surprise fourth stakeholder that emerged during the course of these past 4 years of research. We're really excited to work with jurisdictions that haven't yet onboarded reg reform because we think we've learned a lot. While we were early in Arizona and Utah, we weren't there before efforts were undertaken. And so what we're really encouraging jurisdictions to do who are just starting to think about reg reform is to consider partnership with a design hub. And this isn't a plug for I4J. We think there's a lot of ways that you can get here. But if you're working with your jurisdiction on this, please tell them to reach out to their educational institutions, to consultants, to anyone in the space who can hold the space for these three very different stakeholder groups to come together. We know from working in Arizona and Utah that the judges and lawyers advancing reg reform are incredibly well-intentioned and incredibly under-resourced, and that they really need that capacity building help. We also know that we have been a safe space for the consumers that we've spoken with in a way that sometimes people from within the profession cannot be. We've heard from our community partners that it's been really helpful for us to be the bridge that helps them learn and connect with each other. And that we've been able to bring them together to the table in a way that we think is advancing equity. We like to say it's law school, not lawyer school. So if you have a law school in your jurisdiction, they should be playing a role in your reg reform effort because knowing and using the law should be for everyone. So we do have a framework that we're sharing. You were promised in the project description or the program description there'd be a digital worksheet. Here it is. Right now this is only available through this QR code, so get it while it's hot. I think we'll attach it to the report that was announced today through that flyer. But this is a 5-step framework that we're sharing with jurisdictions as they begin to think about regulatory reform that we hope will help guide a really community-informed regulatory reform design. So I'm going to leave that up for a few minutes. I promise the next slide just says Q&A, and we have microphones circulating, so if you have a question, wave your arm and someone will bring you a mic.
I do want to mention this QR code is not the same one on your flyer. This is a bonus one.
Bonus QR code, yeah.
But we want you to look into both. Yes, at some point.
Ron.
Thank you for that excellent presentation, and more importantly, thank you for the work you're doing. It's really quite impressive. Do you have a plan to evaluate how things are going and share those results?
Yeah, all of the pilots that are running have some evaluation component. The Domestic Violence Project in Arizona is running as a randomized control trial. The Medical Debt Legal Advocates, the evaluation is really baked in because of the data reporting that we have to do for the sandbox. And the Housing Stability Legal Advocate evaluation isn't set yet. It will partly be funder specific. But yes, that is really the goal with all of these projects is to, they've been lab validated, but we want to field validate them so that we can assure other states that this is a safe way to provide legal help.
Very impressive.
Thank you.
Sure. Since it's a Lowland questions for a second, in the data thing, that we're finding at the court, that's one of the most challenging things that we have now. Because people want to know, okay, is this working? Is this closing the access to justice gap? And it's difficult to measure. And in part, for the ABSs, for example, you can't constantly be asking people for all this information because it's a real disincentive to be in like a licensed paralegal or paraprofessional and or ABS because it's like they just, it's like, leave me alone, I want to do my practice. And so you have to really pick and choose. And I'm on the ABA Center for Innovation on their team who are looking to gather up all this information, and we're finding in that group that it's really tricky to measure all of this. So if anybody in here a data geek and has a great idea, I know that give it to Stacy or to me. I would love to hear how you measure.
Stacy, did I hear you volunteer to work with other states?
To the extent we have capacity, sure, we would love to work with other states on standing up reg reform.
Awesome, thanks.
If there's anyone here from Hawaii, we are currently conducting a study in
We very much
Alaska.
like a Hawaii project.
So we'd like some variety
No, we are a virtual lab, so that is one thing that makes it really easy for us to do projects anywhere.
Thank you. Hi, I'm Danielle. I'm from Oregon, and we are working on our regulatory reform right now, and I think planning for implementation in June. And so I'm thinking, I work for the courts, and I'm looking into what kind of training and resources I can provide to judges. So if somebody can talk about how you prepared the courts for the new licensed paralegals, and whether there was resistance and how that's evolved.
Do you want to talk about that?
Sure. I can start and then, oops, hello. That's as far as it goes. Well, our organization, kind of, our advocates are in and out of the courtrooms. And so there's a level, I think, of familiarity. And what we did was set up a meeting and introduce the advocates, talk about the project, answer questions, and really ultimately what it came down to is sort of selling the idea that, you know, this advocate is going to help, in that you might have one or two people who have no representation. And that can be difficult, I think, for a judge to manage in a courtroom, especially if it's an emotionally charged situation. And so being able to kind of sell this piece of the advocate's gonna sit there, they're gonna support this person, they're gonna help at least with that half of it. And really, I don't think that we had too much pushback. People had questions. There were judges that had questions. I think it did help to introduce the advocates ahead of time and answer questions and just have some humility about it as well. And I mean, for me, that worked, but we already had a relationship. And so that also helped us I think if we were strangers and showed up and said, here's what we're doing, it might have required a little bit more work and relationship building, but I feel like overall it was pretty easy. Stacy, would you add to that, or?
No, I think you covered it.
Yeah, okay.
I was curious how you guys decide which areas of law to explore. I come from like immigration background, and I both know there has been tremendous issues with like notarios, but on the other hand, I work with tons of community-based organizations who I know are already doing this work. So I was kind of curious how you guys go about deciding, or, you know, from the court's perspective as well, like which types of areas of law we think are right for this type of innovation, or is it all types?
So what we're encouraging, and I think that's sometimes a jurisdiction-specific question. So one of the recommendations in this worksheet is that you should have a justice needs survey for your community, but then of those justice needs that emerge, you need to assess which ones can consumers pay for help with, and which ones, because we're producing these like licensed paralegal programs for people experiencing eviction and debt collection. There's not a market for those services. So we've been trying to design into the spaces where there won't be a viable market-driven approach. And so this project at the outset was, the plan was always, let's do domestic violence, then debt, then eviction, and build out a suite of curricula that we hope can be replicated in other jurisdictions where those are the highest needs.
Hi, I'm Chris. I'm from the National Legal Aid and Defender Association. I want to echo Ron's comments. Thank you for a great presentation and for your work. I had two questions. First, there was some discussion about community-based organizations and some of the struggle to get people involved because of the high bar to entry and the training requirements. And obviously, if the training requirements are too high, it defeats some of the whole purpose behind this. And then, of course, on the other side, if the training requirements are too low, you can run into problems. And I was wondering if you could discuss any conversations you all have about finding that balance, that sweet spot of enough that it's meaningful, but low enough that it's not going to prevent people from doing it?
Yeah, absolutely. I can take this question. A lot of the work I4J does focuses on upskilling. So the community-based organizations that we're talking to, we're working with, they're already out in the community interfacing with people experiencing these problems. They know what eviction is. They're working with people experiencing evictions. They're working with people experiencing domestic violence. The curricula we create with amazing, incredible attorneys who help us out and share their time and expertise to do so. They're designed as knowledge gap fillers. So we are not setting out to go teach someone what someone would learn in law school, but instead do it in 60, 80 hours. It's designed in a modular curriculum to fill gaps in their knowledge so that they can add this tool to their tool belt instead of replace work that they're already doing, or to do this work instead of the services they're already providing.
Thank you. And then my second question, sorry, is early on in the presentation, you had some survey data that compared to a lawyer, that people were much more comfortable and confident in receiving legal advice from a trained advocate that didn't have a JD. And I think the lawyer number was 16%. Did you have any thoughts about why people have such a low trust in lawyers?
So that is from a project we ran in Utah on housing. And I think part of that might be, is anyone in here from Utah? Utah has a very, very, very quick turnaround. It is 3 business days from the time you get a notice to when you have to show up or be out of your place. Utah is also a state with treble damages, so it's 3 times rent every day you're still there. A lot of community members think that attorneys, especially in the community we were working, are expensive. They're gonna charge. They already don't have the money to pay for their rent, so how am I gonna pay money to an attorney who, if they tell me I have to stay in my place and not vacate, now I'm facing all this extra money damage that goes into a debt collection lawsuit after. So I think part of that extremely low number might have been location and community specific and issue specific, but it is a theme that we're seeing across. We work with low income communities, very diverse communities as well, where a lot of times lawyers are seen as like coming in to fix a problem and then leaving. It's not, you know, their neighbor next door or the person in the apartment above them.
There's this a lot of projects, right, that are working with community navigators where they're not necessarily attacking the regulatory reform work, and I wonder in your sort of approach and your framework how some of these community navigators programs can learn from you, or where is there overlap? Have you worked with some of them to maybe make sure there's more activity across a range of efforts?
So I'm going to kick that over to Anna because they were navigators, essentially. The lay legal advocates were positioned to give legal information but not legal advice before we launched the licensed legal advocate pilot. So do you want to talk about the difference from your perspective?
I want to make sure I understand the question. Can you restate the question for me?
There are some projects right in South Carolina where they're training folks to be these community navigators. I think to prepare documents, to form of information, and I wonder how much of the framework used for this sort of reg reform work borrowed or augmented and have sort of a range of different ways to provide health or services.
Yeah.
Curious about your thoughts on that.
Yeah, I mean, I think that it's also really important to remember that not all navigators and advocates are the same. So I think when we talk about who can be trained or who can be provided with the ability to do this kind of work, I think there is some sort of assessment of how that person operates in general, right? Because once you start providing services of this level, you can't just do whatever you want. You can't necessarily just get creative. You can't, right? Like, that's the law, right? You can't do that. And so I do think that there's something to be said about like the characteristics of someone who would be successful in this kind of role that should be thought about. And we're thinking about that too. We know our staff. We know who's likely going to follow the rules and who's going to try to step up. And that's our obligation and responsibility as a provider. And I think I take that really seriously, and I think it's important that organizations think about that. And I think that what it really does is refine the skill set. In a way, right, you have this foundational information, right, that we know general things about the legal system. We know how people experience judges. We know how people experience lawyers. We know how they describe what it feels like to show up at a clerk's office and try to ask a question and then be referred to the library, right, where you have to figure it out. So I think having that foundational knowledge, which might be different from what a lawyer has, right? That's not to disparage the training and education of lawyers, but that sort of boots on the ground, I've been watching people suffer through this for years and years and years, gives you a lens so that when you sharpen those skills and you're empowered to be able to just yourself sort of navigate that system differently, the quality of the service you can provide is certainly much higher, but it's also much richer. And so when we talk about empowerment and we talk about things like poverty and violence and sort of healing from that, being able to have an experience that tends to the trauma associated with living in those conditions is life-changing for people. And I believe that you get that when you take lay folks and train them in this way. You have the ability to get that. That's my answer. I'm not sure if that's where you were going, but that's what I would say. Stacy, I don't know if you want to add to that. Or
So I think that also that beyond that, I'm not sure, I wouldn't even touch that because it's so great. But I thought the question also probably lends itself to what you can do to replicate in your state. If you're interested in any of the things that we've talked about today, almost all of it, even though a lot of it will start maybe like this, these folks will come up with an idea, like the housing thing that went in yesterday. That was Stacy and folks saying, we have this proposal, and then puts it in, and then Stacy keeps calling me, why haven't you done anything? That kind of thing. But ultimately, you're going to need the regulator in your state, which is probably the court, to be on board with this stuff. And from my observation, doing this now for the last 5 or so years, paying attention to the issues, and I'm aware of a lot of courts doing it, Oregon and Washington's had their issues with their triple LPTs, and California, Illinois, I can think of that have things going. I'm not sure about South Carolina. The ones that seem to really actually go forward at least more quickly, Utah and Arizona, it's because they were justices driven. So the courts have driven it. The ones in the states where the bar associations start and have a group, well, there's all kinds of things that go with that. Is it threatening our livelihood? Is it encroaching? What about the professionalism and ethics and concerns? And so it seems to me that you're probably, if you're interested in any of this, if you need to get the ear of the Supreme Court. And it's not as difficult as that might sound to some people. I mean, really, just call them up because that's their job. And they would be willing to listen, I bet. At least one of them would. And that's what you need to get somebody behind that then will listen to these folks or put together their own task force and think this is a good idea. And that's what Utah too. It was Dino Jimenez, who's now retired, but he was a justice that really propelled it and kept pushing forward. And that's what it takes. So I think you need to get your states interested, and they might not want the whole thing, but they might want another part, or frankly develop something new that then we can steal.
Certainly, and we have some friends in Alaska who are in the audience, I believe, who went into their Supreme Courts with
consumer and CBO buy-in, and I think that it's really hard to deny that something should be done when you also have those groups in support, certainly. So.
Thanks, Carla. It sounds like these could be indicators for a place that would be really good for giving this temporary reform thought. So you have these kind of advocates that are buying in and maybe have the experience
In a similar way.
Yeah, I worry a little. I mean, sometimes I hear from states, they're like, oh, we don't need reg reform, we have navigators. And so if you look at the research on navigators, like so much of the training is don't give legal advice, don't give legal advice, don't give legal advice. And I think there's real value to navigators in the justice ecosystem as wayfinding through a lot of what lawyers do is just procedural like guidance, and you don't need a law degree to do that. But one thing we really try to message is that what we hear from consumers is they want someone to tell them not like, here's a form, but like, what's the consequence of what I put in here, and please guide me in completing this. I think we have time for one more question. Katie.
This has been incredible to watch, and I have been listening to you all talk from the perspective of we in Michigan have launched a Supreme Court task force for well-being. And a lot of what you're referring to around how people engage and perceive attorneys is really related to how well attorneys are doing inside of their own practices and lives. And I was curious if there's been any discussion around how engaging in a collaborative way with helping professions that counsel people with training on how to hold space for trauma or compassion fatigue, that have expertise that we as lawyers often don't have, may have a cascading benefit in lawyer well-being by engaging with one another that way.
I think that's a Kaylee and Anna question.
So a little bit more about me. My background is actually in mental health counseling prior to coming to law school. And creating legal education that is trauma-informed is like my personal passion. And I think that every law school class should be trauma-informed and teach attorneys how to be trauma-informed. Because like you said, it's not only good for clients, it's good for practicing attorneys themselves. And I defer to Anna for the CBO perspective on that.
Yeah, I mean, to me, it's an obvious connection. Attorneys don't come from an alternate universe. They're products of the communities that are saturated with violence, saturated with poverty, et cetera, and many of them have had their own experiences, and sometimes that's what drives them into law school. And so I think, much like that's what might drive someone to become a social worker or a counselor. And so there's that piece, and like, how do we tend to that, and the burnout and the exhaustion that can happen in helping folks in similar circumstances. But I also think the stress level, I mean, I know lots of attorneys and work with them, and they all seem really intense. Even when they're not in the courtroom. And so, I just think that's a helpful tool in general for high stress, professions. And then you add the layer of then they go into the courtroom, and I love to sit in a courtroom and watch the dynamics play out. And you're talking about going in and out of really intense structural power dynamics, and that has an impact on people. So yes.
Thank
it
you.
would be helpful.
All right, I think we're at time. Thank you all so much.